Good morning, everyone. Thanks again for tuning in. Today, once again, I have immigration attorney extraordinaire, Paul Dwyer from New York City, joining me to have a discussion, an exciting discussion about what may be coming up post-November. We're having a presidential and the whole, Congress, a lot of congressional people are going to be competing for their jobs, and hopefully we'll have an entire new world after November come January. So within that context, I want to ask Paul about his wish list regarding immigration, how he sees things possibly changing for the better, and what he'd like to have done if we have a new administration and we have a new Congress. Good morning, Paul.
Good morning, Ali. Well, good afternoon from here. Nice to see you as always, and nice to talk to everybody. So when I was preparing for this, as I looked at it, I realized that there are existing provisions in the Immigration Act that just give sweeping powers to the president and to the executive generally when it comes to immigration, and that these traditionally have not been used to the extent that they have been during the Trump administration. And I think what we've seen now is the extent to which those provisions can be abused and are subject to abuse, or at the very least that they're, because the other side would never say that they're being abused, but they're used in a way that operates only to the detriment of non-citizens in the country. And so I think when you have that, and then there's been developing over the years I want to say almost an antipathy or an adversarial approach to immigration by both DHS and the Executive Office for Immigration Review within the Department of Justice. And those are the two agencies that are charged with interpreting and enforcing the immigration laws. And they've shown themselves time and time again just to be so adversarial to immigration and to immigrants. And they have, basically set themselves as a roadblock between the immigration benefits that Congress has said people are entitled to and the people who are applying for them. And so I think those two things have to be addressed in any new immigration law that we would like to see. And so I proposed, or I came up with like a list of things that I think need to be done in order to put ourselves on the pathway to a more fair and just and efficient and sensible and common sense.
So what are the fixes? What are fixes that you're proposing?
So the first fix, I think the most important one, is to repeal the section of the Immigration Nationality Act at section 1182F, which gives the president this broad sweeping power to suspend the entry into the US of any alien or classes of aliens as he sees fit. And that's been upheld by the Supreme Court in Trump versus Hawaii in a very sweeping decision. And so that has to be abolished. That has to be repealed completely. The Immigration Act has numerous provisions that make people inadmissible and deportable on the basis of crimes, national security, terrorism, public health, you name it. So it's really unnecessary to give this additional power to the president. And as we've seen, this president has just consistently abused it. And the second provision, or fix, would be to repeal the provision of the Immigration Nationality Act, which says that the Attorney General is the final arbiter of all issues of immigration law, and then a corresponding regulation that gives him the power to refer any decision of the Board of Immigration Appeals to himself, and so that he can rewrite it. And again, that's during this administration, that power has been abused so much that the Attorney General has essentially rewritten entire swaths of immigration law. And that completely undermines the notion that we have an independent immigration court system. So I would repeal that. I would rescind all of the Trump restrictions on asylum, both the regulatory and their other restrictions. I would provide a pathway to dreamers, and I would provide a pathway to citizenship for dreamers, and a pathway to citizenship for all the other 12, 15 million undocumented people living in the country, which is easily done with a fix to the requirements for being eligible for adjustment of status.
I mean, you can just add on, you can just bring back 245I.
Yes, yeah, that would solve the problem. That would solve the entire undocumented in the US problem. And the only
No,
problem is people are going to say it's an amnesty, but then, well, so what? I mean, it's a problem that has to be addressed. It's not going to go away. I would establish a new class of unskilled labor and farm workers visas for largely for people who are current asylum seekers. Not to say that they couldn't currently seek asylum, but that they would be also eligible, if they're not eligible for asylum, that they would be able to apply for these workers visas. These are the jobs that asylum seekers typically end up doing anyway. The industry depends on them and there's a need for it. And it would relieve this pressure on the asylum system, both in terms of like trying to constantly revise the definition of asylum to fit new and evolving problems, and also just the sheer physical number of people who are seeking asylum. I would abolish mandatory detention of people based on their criminal convictions, which may be very trivial shoplifting incidents that happened like 20, 30 years ago that caused them to be detained without trial or without the possibility of a bond hearing. Immigration judges are trained to do this and they should be able to do it. I would abolish the distinction between arriving alien and people who have been previously admitted so that people are not detained here endlessly for years, again, without access to a bond hearing. Again, as I mentioned earlier, I would allow people who have entered the US without inspection to be able to apply here for adjustment of status, because that inability to do so is what has caused the massive increase in the number of undocumented people in the US. They can't leave in order to obtain immigrant visas overseas, and they can't apply to adjust their status here, so they're stuck. I would change the standard for cancellation of removal, which is a form of relief available to people in immigration court proceedings, back to the extreme hardship standard and away from the exceptional and extremely unusual hardship, which is a standard that is so high that it's basically unworkable and that nobody can reach it. Most important, or not most importantly, but equally important to all of those, I would establish an independent Article 3 court in the same way as we have an independent tax court and an independent bankruptcy court, with judges who are appointed to those positions for a term of 14 years. And they would be free from the Department of Justice and free from political interference and political influence. And finally, I would establish a customer service unit within each USCIS field office so that people who are applying for perfectly routine immigration applications and benefits, like people who are seeking adjustment of status, who are applying for immigrant visas, so they can go to the local USCIS office and have assistance in preparing those applications. And that would relieve the financial burden on people who are forced to hire lawyers to do what should be relatively routine applications. And it would also force USCIS to be more customer service oriented and to work with people in order to achieve the goals that Congress has set.
So that's an amazing wish list, and I just want to reiterate that it's not really all that far out. I mean, a lot of these are supported by AILA, the American Immigration Lawyers Association, and by a vast majority of professionals in the field. So these steps that you're suggesting is really easy. They're easy fixes.
They're easy fixes, and also I want to point out that a lot of them, especially when it comes to bond hearings, or eligibility for bond, and for changes to cancellation of removal, and for an independent immigration court. These are all changes that the immigration judges have called for over and over and over. Like national associations of immigration judges have repeatedly made calls to restore discretion to immigration judges in decision making and allow them to do bond hearings for people rather than have them locked in mandatory detention. And this huge burden then on the district courts with people seeking habeas petitions. To get them out of jail.
You know, otherwise, what is the point of being an immigration judge if you don't have discretion to decide many of these issues?
Of course.
So, you know, it's also fiscally responsible, Paul, because once you decrease the backlogs, once you make people, you know, provide opportunities for people to work and pay taxes, once USCIS is able to receive all this filing fees, I mean, the taxpayer ends up saving money. Once you free up all these for-profit prisons, which are just unconscionable,
yes,
you know, because of mandatory detention. I mean, it's just, it's fiscally conservative. It should be a Republican position, not just a Democratic position.
Yes.
Which brings me to my last question. I mean, we've been, this is not our first rodeo, yours or mine. So we've been discussing this for really over 20 years. I mean, we've had Democratic Congress presidents and Republican administrations, and none of this has been done. You know, what do you think we can do to make Congress responsive to these really simple demands that saves taxpayer money?
One of the ways to approach it is to perhaps step away from what I've always called and been very critical of as the social worker approach to immigration law. And instead of presenting this as if you were a good person, you would really care and you would do this. And if you really cared about immigrants, you would do this and blah, blah, blah. And that's really not a way to get people on board with anything. You can't guilt trip people into passing legislation or doing changes like this. So really, I think what has to be done is it has to be presented as this is a practical approach to this problem. Right? This is a practical solution to an intractable problem. We have a law in effect. It doesn't work. It hasn't worked for a while. It's reached a point now where it's been made unworkable by the current administration. And so we need to change it. It has to be changed, and it has to be changed in a way that is just practical for everybody.
So last question, Paul. So we have a pool going at the office as to who Biden might pick for VP. First of all, did you want to enter the pool? $10.
Yes.
Okay, so who's your pick?
As in, like, who would I like to see, or who do I think is likely to be chosen?
Who do you think? You want to win the money?
Okay, I do. So I think it's going to be Kamala Harris.
Kamala Harris. Okay,
I think
so
he's going to choose Kamala Harris.
Huh? Okay. Well, I hope you're a good boy, and Santa's going to give you all kinds of surprises come December and get all these wishes a reality for you. And
Santa's good to me in that I win the pool, is what I was thinking.
All right. Thank you so much, Paul.
You're welcome. Thank you.
All this information, and it's just, we need more time, but I just love talking to you about all of this.
Likewise. It's been great.
Have a great day.
You too. Bye-bye.